The journey to the government house in Bayelsa State for Mr. David Lyon appears to have been stamped as the Supreme Court threw out the appeal filed by Senator Lokpobiri, challenging his nomination as a candidate of the All Progressives Congress. The Apex Court, in a unanimous decision, dismissed the appeal filed by Senator Lokpobiri, challenging the nomination of Lyon as the APC flag bearer in the November 16 governorship poll. The court, in the lead judgment delivered by Justice John Okoro, held that Senator Lokpobiri failed to file his suit within the mandatory 14 days stipulated in the 1999 Constitution. Justice Okoro stated that the provisions of Section 285, subsection 9 of the 1999 Constitution was categorical and emphatic that all political cases must be instituted within a 14-day time frame from when the cause of action arises. The appellant filed his suit 24 hours outside the time allowed by law for him to do so. While the lawyer to the appellant was unavailable for comment, lawyers to the APC and Mr. Lyon applaud the verdict of the court.
Well, the implication of the judgment is that the pre-election matter challenging the nomination and sponsorship of Chief David Lyon as the lawful candidate of the All Progressive Congress in the November election has been affirmed by the court. The court has held that there was no proper challenge because the lawsuit filed by Senator Lokpobiri was filed outside the prescribed period provided by the Constitution.
What we take away from this decision is the fact that the Supreme Court at this point has settled the question of whether the Interpretation Act generally applies to the provision of Section 2859 with respect to election matters. That issue has been finally settled by this decision.
The appellant, Senator Lokpobiri, had prayed the Apex Court to void the decisions of both the trial court and the appellate court in Port Harcourt, which held that his case was statute barred and no longer has life as at the time it was instituted. The former Minister of State for Agriculture averred that the two lower courts erred in law when they held that he ought to have filed his grievances from the date the result of the primary election was announced, and not from the date his opponent's name was submitted to the electoral body.